Did you know that in the 90s in the United States you can be considered a weapon if you make the correct tattoo on your skin? We will see in this episode how the first open source activist achieved coding to be considered just another form of expression and thus protected for the First Amendment laws of freedom of speech. We will explore how these open source movements created a conflict between the two pillars of capitalism, individual freedom and private property. At the end of this episode, we will see what happened in Europe and how the European civil society adapted these open source ideas to the European culture, and how the open source movement took another different way than in the United States. Follow me in this episode of Code of Culture about code as a speech. The fight to recognize coding as speech started in the early 90s United States. In 1990, Phil Zimmermann created PGP, a tool to encrypt communications and emails. The US government, however, considered PGP to be a weapon and classified it as ammunition subject to export controls. PGP-2 was released in 1991, and Zimmermann, in the release, included the copy of the United States Constitution as a freedom of speech statement. Zimmermann argued that encryption software was just another form of speech and therefore protected under the First Amendment. In 1993, Zimmermann was investigated by the US government for violating export laws by distributing PGP overseas through the internet. He was eventually cleared of all charges, but the legal battle had begun. During these first years of the 1990s, some organizations arise, and these were the first free software organizations. Along with some activists tattooing themselves the RSA algorithm as a protest, it started to appear the Electric Frontier Foundation that was founded in 1990, and it was a non-profit organization dedicated to defend the civil liberties in the digital world. It became a key player in the fight for free speech rights of server code, and it was the author and the tutor of the GPL license. Also, in 1994, a group of lawyers and activists published the Crypto Law Review, a journal dedicated to exploring legal issues surrounding encryption and free software. And also other local groups of hackers were quite active in both coasts. And then, in the early 90s, Daniel Bernstein, a professor of mathematics and computer science at Illinois Chicago, developed a program called Snuffle that encrypted emails and messages and made them more secure. Bernstein wanted to publish this program as open source software, but he was concerned that doing that would violate the US export laws. He couldn't even give classes of cryptography when non-US citizens students were in the same class. He filed a lawsuit against the US government in 1995 challenging the constitutionality of the export laws under the First Amendment free of speech protection. The government argued that the encryption was a form of munition and therefore subject to export control laws to prevent it from falling into the hands of foreign governments and terrorists. After some years, in 1999, the Ninth Circuit Court of Appeals ruled that the export control laws were unconstitutional because they violated Bernstein's right of free speech. The court held that software code was a form of expression and therefore protected by the First Amendment, and that the export control laws were an impermissible prior restraint on Bernstein's right to publish his code. This was a great win for the free of speech activists, and being code recognized as speech was the final step or so they thought, because then, 1 year before, United States made the Digital Millennium Copyright Act, or DMCA. This law criminalized the production and dissemination of technology, devices, or services that can be used to circumvent digital rights management measures, or DRM, as they are known. The Digital Millennium Copyright Act was criticized for its potential to limit the freedom of speech rights of programmers and other technology users. One of its major concerns was that the anti-incursion provision of the law, which make it illegal to create or distribute technology that can be used to bypass DRM, even if the underlying purpose is otherwise legal. So, they can sue you for programming. And actually, this is what happened to Dmitry Zlyarov. He was a Russian programmer who was arrested in the US while he was attending the Black Hat in Las Vegas in 2001. He was working in a company creating software that could be used to circumvent the encryption of Adobe PDF files. He was charged for violating the DMCA, but the charges were later dropped after he agreed to testify against his employer. And right now, after winning the battle of freedom against security or freedom against government, the free of speech activists are fighting a totally different front of freedom against property. The Digital Millennium Copyright Act started to affect European citizens in early 2000s, and that was the trigger of the open source movement in Europe. But Europe is not one country, but a group of them with different laws and courts. And the same situation can be considered legal or illegal depending on the country. Let's see an example. Here we have two programmers that made almost the same program. They just wanted to see their DVDs in Linux. And to do that, they had to bypass the copyright protections in the DVDs. The first one was Norway, John Johansson, and he created the DCSS program, and he was found non-guilty. The other one was the creator of DVD John, Sebastian Hahn, in Germany, and he was considered guilty. Actually, he had to pay 8,000 euros and 6 months of prison. However, this was not the big one. Did you remember the Pirate Bay? The Pirate Bay was a web page that was offering torrent files for movies, video games, etc. In 2006, the Sweden government closed Pirate Bay, but they alleged that they were not distributing content, but just hashes. And this was the spark that started the Pirate Party in Sweden. From the years coming, in the European Parliament, lefty parties started to create programs that promoted open source movement from public administrations, creating, for example, the UA public license or the Open Source Observatory and Repository. Also, from 2009, the Pirate Party had achieved representation in the European Parliament. And finally, in 2019, a French programmer, Stéphane Crosatier, was sued for copyright infringement for creating a software called BruGriffon to create native web pages. In 2019, the criminal court in Paris acquitted Crosatier of all charges, finding that he had not intended to facilitate copyright infringement and that his software tool was a legitimate product. The court also ruled that Crosatier had a right to free expression under the French law, and that this software did not violate the copyrights of Adobe system. This shows us how the principles and the ideals of the activists in the early 90s in the United States for freedom of speech has evolved in Europe and has become a footprint of European institutions. Thank you for seeing this episode of Code of Culture on Code as Speech.